Hello and welcome to Daily News Simplified, where we take up important articles of the day from the newspaper and discuss them in detail as per the demands of Civil Services exam. Articles covered today are displayed on your screen and their notes in PDF and Word format are provided in the description box down below. Without further ado, let us begin. Starting off with the first article of the day that appeared in Indian Express on August the 5th of the year 2023. This date, it marks 4 years without the Article 370. And in this regard, this news deals with political and security implication of revocation of Article 370. This topic is important from exam's point of view. As UPSC in GS paper 2, it highlights Indian Constitution, historical underpinnings and its significant provisions. Further, revocation of Article 370 also altered the federal structure of the country with respect to Union government and then state of Jammu and Kashmir. Hence, this topic is also important because UPSC in GS paper 2 also mentions functions and responsibilities of union and states, further issues and challenges which pertains to the federal structure of the country. This topic has also been asked in mains before, which is apparent from this PY on nature of federation in India. Further, the duties of union with respect to states is covered in prelims of the year 2023, where it asked a question on constitutional responsibility of the central government with respect to protection of states from internal disturbances. Hence, in the scope of today's discussion, we will first take a background of how that Article 370 was inserted into the Indian Constitution. Further, we will also discuss the key changes that were made post revocation of Article 370. In the end, we will discuss the political and security implication of such a move as it had a significant impact on politics and security infrastructure of Union Territory of Jammu and Kashmir. Hence, let us start off our today's discussion in taking a background of Article 370. Now, in the year of 1948, the Government of India, it signed a treaty of accession with then ruler of Jammu and Kashmir, who was Maharaja Hari Singh. Now, this treaty was signed because the government, it wanted to protect the state of Jammu and Kashmir from Pakistan's aggression. Now, post signing of this treaty, an article that was Article 370, it was inserted into the Part 21st of the Indian Constitution, and it was titled as a temporary, transitional, and a special provision in the Indian Constitution. This article, it provided a special status to the state of Jammu and Kashmir. And as per this article, the central government, it needed the state's government concurrence on application of laws, except in the field of defense, foreign affairs, finance and communication. Also, residents of Jammu and Kashmir, they lived under a separate set of laws, such as laws which were related to citizenship, ownership of property. They had a separate penal code and fundamental rights when you compare them with other Indian citizens. Further, it also provided for insertion of Article 35A to the Indian Constitution, which gave powers to the State Legislative Assembly of Jammu and Kashmir to define the permanent residents of the state and their special rights and privileges. However, in the year of 2019, the President of India, he promulgated a constitution application to Jammu and Kashmir order, and this order, it stated that the provisions of Indian Constitution became applicable to the state of Jammu and Kashmir. This effectively meant that all provisions that formed as a basis of separate constitution for Jammu and Kashmir, it stood abrogated. And in this regard, Article 35A was also scrapped automatically. Also, the Government of India, it enacted Jammu Kashmir Reorganization Act of the year 2019, which was then passed by the Parliament. This act,
It reorganized the erstwhile state of Jammu and Kashmir into two union territories. The first was Union Territory of Jammu and Kashmir, which was provided a legislative assembly. And the second, it was Union Territory of Ladakh, which was without a legislative assembly. Now, post reorganization of the erstwhile Jammu and Kashmir, there were key changes that were made into the politics of Jammu and Kashmir. Let us discuss these key changes in the next slide. Now, the first important change was made in the legislative sphere. Out of 354 state laws that were enacted in Jammu and Kashmir, 164 laws they were repealed, whereas 138 laws they were modified. And on the other hand, 170 central laws they were made applicable to the Union Territory of Jammu and Kashmir. Now, several critical legislations that were passed by Government of India, it became now applicable to the Union Territory of Jammu and Kashmir. For example, laws that were related to transparency and accountability, such as RTI Act of 2005 and Whistleblower Protection Act of the year 2014, they became applicable to Jammu and Kashmir. Further, laws that was enacted for protection of marginalized section, such as Prevention of Atrocities Act of the year 1954, as well as Scheduled Tribes and Other Forest Dwellers Recognition of Forest Act of the year 2007, they were also made applicable to the Union Territory of Jammu and Kashmir. Also, the laws that granted educational rights to children, such as Right to Education Act of the year 2009, were also made applicable to the Union Territory of Jammu and Kashmir. Now, Government of India, it also introduced an array of central government schemes to the Union Territory of Jammu and Kashmir. Now, citizens of Jammu and Kashmir, they were able to reap benefits of central schemes such as Ayushman Bharat, Atal Pension Yojana, Pradhan Mantri Kisan Yojana, and Pradhan Mantri Jan Dhan Yojana were applied to citizens of Jammu and Kashmir. Further, under the National Saffron Mission, more than 3,500 hectares of land in Jammu and Kashmir, they are now being rejuvenated for saffron cultivation. Also, in order to boost tourism and connectivity with the Jammu and Kashmir, 11 airports in Jammu and Kashmir were being considered under the Udan scheme of Union Government. Further, the health sector has now been transformed with opening up of 2 AIIMS hospital and 5 new medical colleges. Further, revocation of Article 370, it also led to dilution in domicile laws of the state, as Article 35A now stands repealed. Now the Parliament, it has redefined the domiciles in Jammu and Kashmir, and now it also includes persons who have been resident of the state for more than 15 years. Hence, the domiciles now, they also include children of central government and central government aided organization employees who have served Jammu and Kashmir for a period of more than 10 years. And hence, 4 lakh people, they stand to benefit from dilution of such domicile laws. Also, dilution of such domicile laws have several other benefits, as it can act as a catalyst for industries and multinational corporations, which will then provide ease in procurement of land, and it will help bring more investors into the Union Territory. Further, central government employees who are now posted in Jammu and Kashmir, they can now reap same benefits as in the rest of country. Also, it helps integration of social fabric under the new domicile law, as by granting domicile status to marginalized sections such as Pakistani refugees and members of Kashmiri Pandit community, it will enable them to enjoy the diverse employment opportunities in the state administration. Now there are key implications of such changes. For the scope of today's discussion, we will take a look at political and security implications of such a move. Let us deal with such implications in the next slide. Now first, let us deal with the political impact of revocation of Article 370. Now Union Territory of Jammu and Kashmir, it witnessed many firsts in the 4 years period. Now, the first changes in this regard was district council elections, as elections to district developmental councils, also known as DDCs, they happened in all 20 districts of Jammu and Kashmir, and this took place in the November and December period of the year 2020. And this it enabled the hopes of democratic process at the grassroots of Jammu and Kashmir society. Now, DDCs in Jammu and Kashmir, they were earlier called district planning committees, and the members they were nominated by the state government. However, with these changes, the members they now became elected members, and hence it enhanced the grassroots democracy in the union territory. Further, revocation of Article 370 it also enabled the formation of Delimitation Commission. As the central government, it constituted a 3-member Delimitation Commission which was headed by Justice Ranjana Desai in order to carve out 90 assembly constituencies of Jammu and Kashmir, and it included reserved ones for scheduled castes and scheduled tribes. In the final report of Delimitation Commission, it increased the number of seats in Jammu division from 37 to 43 seats. It further increased the number of seats in Kashmir area from 46 to currently 47. The Commission's report it also provided reservation for 9 constituencies for scheduled tribes, as well as 6 constituencies were reserved for members of scheduled castes. Further, it also provided for nomination of 2 Kashmiri Hindus and 1 seat for displaced person from the area of Pakistan occupied Kashmir. Now it also enabled extending of quota system, as the center it has now tabled a legislation in Lok Sabha. It seeks to include 4 new groups into the category of scheduled tribes in the state, and these groups are Gadda Brahmin, Koli, Padari tribe and Pahadi ethnic group. Now the second significant impact was on security sphere of the state, as the number of stone pelting incidences in the state they have reduced significantly. Now, with the unprecedented number of security forces in the valley and the strict actions that were taken by central agencies, the incidences of stone throwing have been reduced virtually to zero, and incidences of terrorism have also witnessed a significant decline. Now, according to a data that was published by Ministry of Home Affairs, there were 76 incidences of stone pelting in the state during the year of 2021, which is significantly less than 222 stone pelting incidences in the year of 2020 and 618 stone pelting incidences in the period of 2019. Hence, from this data you can see that the number of stone pelting incidences they have reduced significantly. Further, the arrests of militants they have also gone up, as the arrests of overground workers they were 82 in the year of 2019, and it increased to number of 178 in the period of 2021. Also, the government's data it shows decline of 32% in acts of terrorism, which was taken between August 5th of the year 2019 and June of the year 2022. Further, the deaths among security personnel they have also reduced by 52%, whereas deaths of civilians in the valley it has reduced about 14%. Also, a reduction of 14% was recorded in admission of terrorists. Thus, it has a significant positive security impact on the Union Territory of Jammu and Kashmir. Hence, judging by the political and security impact, we can easily conclude that the revocation of Article 370 has been beneficial for the Union Territory of Jammu and Kashmir. This was all for today's discussion on revocation of Article 370. Now moving on to the second article of the day, which appeared in August 1st in Indian Express. Now this article, it deals with the employment picture that exists in the country. Also, it gives us certain data about number of people employed, and it also gives us the classification of categories and number of people who are employed in these categories. Now this topic is important from GS paper 3 perspective, as it deals with Indian economy and issues which are related to development and employment. Further, the topic of employment, it also appeared in mains of the year 2016, which dealt with how globalization has reduced the number of employment in the formal sector. Further, the topic of employment in one form or the other, it also appears in prelims, which is apparent from this PYQ of the year 2017 on National Career Service. Hence, the data which is provided in this article, it can be used for answers in GS paper 3 in this year's mains. Hence, in the scope of today's discussion, we will first take a look at data which are given in this article. Then, we will discuss how the trends of self-employment in the country are on the rise and implications of such developments on Indian economy. Hence, let us start off our today's discussion with data on employment sector. Now, these all data, they are provided by Center for Monitoring of Indian Economy, also known as CMIE. And according to CMIE, the total number of people employed in India between the year January and April of 2023, it stood at almost 413 million. And as you can see from this graph, it is much more than the number of people who were employed during the period of pandemic. Further, the second chart, it categorizes the people into 4 categories. These are small traders and wage laborers, farmers, salaried class, and the business class. And from this chart, 2 things they stand out. The first is the order of how people in India are employed. From this chart, you can see that the bulk of people are employed as small traders and wage laborers as well as farmers. Whereas the third biggest category is that of salaried class. Whereas the fourth is that of business class. Now the second thing is to note that only one category among these 4, they have recovered from pre-pandemic level. And this category is that of people who are employed in businesses. However, all other these 3 categories, they still remain below the pre-pandemic level. Now, let us take a detailed examination of data that deals with people who are employed in business category. Let us deal with this data in the next slide. Now, there are 3 subcategories for those people who are considered among business class. The first category, it is termed as businessmen, and these include people who set up large businesses that leverage capital and humans to run these businesses. These people, they manage some fixed premises such as office, a shop, workshop, or a factory, etc. The second category, it is termed as qualified self-employed professionals, and this category includes people who run their own professional enterprise and leverage their own expertise. And these include people such as doctors, lawyers, consultants, professional chartered accountants, and so on. And the third category is that of self-employed entrepreneurs. These people, they run their own business enterprise, but these enterprise, they do not leverage much financial capital, human capital, or even professional skills. For example, taxi drivers, barbers, beauticians, estate agents, brokers, insurance agents, astrologers, etc., they constitute self-employed entrepreneurs. And after you take a look at this chart, it is quite clear that the self-employed entrepreneurs, they account for largest share of about 70 to 80% of all entrepreneurs in India. The second largest share is that of businessmen, who constitute about 15 to 20% of all self-employed entrepreneurs. And the third category is that of qualified self-employed professionals, who account for about merely 1 to 2% of total self-employed persons. Now the composition of these people, they have changed considerably since the year 2016. Let us take a look at this composition in the next slide. Now from this CMI data, it is quite clear that the share of businessmen, it has decreased considerably from 2016 onwards. And this fall in share of businessmen, it was offset by an equal rise of self-employed entrepreneurs in the country, which is quite visible from this development in the year 2013. Hence, at the macro level, we can conclude that the business class, who constitute a well-to-do entrepreneur, they are under a secular decline. And more importantly, the actual rise of Indian entrepreneurs is happening in the sphere of self-employment, which reflects poorly on Indian economic conditions. Now, self-employment is a category where remuneration of these people are directly dependent upon profits which are derived from goods and services which are produced by these people. Now, as per PLFS report of the year 2019-20, there has been a rise in self-employment, as about 53.2% of rural household and 30.7% of urban household, these people are engaged in self-employment. Now there are few issues that are related to self-employment. Let us take a look at this issue in the next slide. Now the first issue that pertains with self-employment is that it is dominated by agriculture sector. As about 60% of people who are self-employed, they are engaged in agricultural activities, and by virtue, they are less productive than people who are engaged in other sectors. Further, self-employment in the country has only led to a fraction of job creation, as only 4% of self-employed people, they hire workers from outside. Also, people who are self-employed, they witnessed a below average earnings, as they average only about 8,000 per month, which is lower than even regular workers. Further, there is a significant pay gap that exists in self-employment, as males, they earn about 2.67 times more than their counterpart females. Further, most of the self-employed enterprises in the country, they remain unregistered. As an NSSO data, it highlights that almost 63 million of self-employed entrepreneurs, they are currently unregistered. Further, there are systemic inefficiencies in self-employment ecosystem. As the economic survey of the year 2018-19, it highlighted that the incentives that are provided by the government are such that they incentivize an enterprise to continue to stay small. As in the case they decide to grow, they will be subjected to further bureaucratic hurdles, which then disincentivizes entrepreneurship ecosystem in the country. Now there are several suggestions that can be inculcated in order to improve the self-employment ecosystem in the country. Let us deal with this suggestion one by one. The first suggestion pertains to improving the access of capital to these self-entrepreneurs, as this will enable reinvestment in their business enterprise, which will further lead to expansion of businesses. The second suggestion in this regard is to provide access to these self-entrepreneurs with a good quality skill training, as it will help them improve their business productivity in a better way. There is a further need to increase formalization of self-employment in the country, and this will help capturing the self-employed entrepreneurs' contribution to the Indian economy. Further, there is a need to simplify taxation policies, as it will help bring these self-entrepreneurs in the formal tax net in the country and will also reduce the amount of tax evasion. Also, there is an imperative need to overcome the bureaucratic hurdles, as easing the process of registration and reducing the inefficiencies that has resulted into perverse incentives will help the self-employment ecosystem in our country, Hence, self-employment ecosystem in the country has a potential to increase the macroeconomic growth of the country. And this can be done by improving their access to capital, skill training, formalizing their participation in the economy, simplifying the taxation policies, and reducing the bureaucratic hurdles will further help the self-employment ecosystem in the country. This was all for today's discussion on the employment picture that exists in India. Now moving on to the third article of the day, which appeared on August 5th in the Indian Express. Now, after nearly 5 years of negotiation, which involved the government, technology companies, and civil society representatives, the central government it presented in the parliament the Digital Personal Data Protection Bill, and this legislation it outlines the procedures which governs the collection and utilization of information and personal data of Indian citizens by both corporations and the government. Now, this topic is important from GS Paper 2 perspective, which deals with governmental policies and interventions in development of various sectors. Further, this topic is also important from GS Paper 3 perspective, which deals with basics of cyber security and security of personal data constitute an important component of cyber security. Also, a similar question it appeared in mains of the year 2018, and this question it asked us to deal with Justice B.N. Sri Krishna Committee report on protection of personal data in the cyberspace. Further, protection of personal data is important from perspective of right to privacy. Hence, it is also important from prelims point of view, which is apparent from this PYQ of the year 2018 on constitutional right to privacy, which falls under the Article 21 of the Part 3 of the Indian Constitution. Hence, in the scope of this article, we will first discuss the features of this Data Protection Bill of the year 2023. Moving forward, we will discuss the significance of such bill on protection of personal data in the country, and in the end, we will also discuss the issues that may be pertaining to passage of such bill. Hence, let us start off our today's discussion with features of Digital Data Protection Bill of the year 2023. Now, this Digital Personal Data Protection Bill was a much needed bill, and this bill it enables the individuals who are referred to in this bill as data principals to govern their own personal digital data, and it also drives enterprises who are referred to as digital fiduciaries to process the personal data of individuals in a lawful process. Further, this bill also provides for extraterritorial coverage, as enterprises who are based outside the India but they serve individuals who are present in India are also expected to adhere to the provisions of Digital Personal Data Protection Bill. Further, this bill frames out the rights and duties of a digital citizen, also known as digital Nagrik, on one hand, and on the other hand, it obligates the data fiduciaries to use the collected data in a lawful manner. Further, enterprises they will have to review the current ways of working, especially with respect to personal data of individuals such as employees, consumers, merchants, vendors, etc., so that they will be able to honor the rights that individuals may exercise, such as right to access, right to update or erase their personal data, etc. Further, non-adherence to provision of this bill will obligate the listed entities to a sanction and commercial penalty which may go as high as 250 crores. Now, after we have discussed the key features of this bill, let us discuss what is the significance of such important features. The first important significance is that this bill provides rights and duties to data principals. As an individual whose data is being processed, they are called as data principals, and they will have the right to obtain information which is related to processing of their data and seek correction or erasure of their personal data and nominate another person to exercise their right on their behalf in event of deaths or incapacity. Further, this bill also provides that the personal data will only be processed for a lawful purpose after an individual they have given a consent, and a notice it must be given to these individuals before seeking their consent. And this notice it should also contain details about personal data which is to be collected and the purpose of processing such personal data. However, this consent given may be also withdrawn at any time by the data principal. Further, this bill also provides for an establishment of data protection board, which will further strengthen this legislation and thereby enable compliance, remedial measures and penalties wherever they are necessary. And this data protection board, it will function as a digital office. It will handle complaints, allocate cases and make decisions through a techno-legal means which will enhance the efficiency and transparency of entire process. Further, the appeal from this board can be directed to the Telecom Dispute Settlement and Appellate Tribunal, also known as TDSAT. Additionally, failure to comply with bill's provision will result into significant fines for big corporations, as this bill it seeks to hold entities like internet companies, mobile apps and businesses accountable for collection, storage and processing of citizen data, and this will help to ensure the right to privacy of an individual. Further, this bill also includes some business friendly provisions, which includes eliminating criminal penalties for non compliance, and it facilitates international data transfers. Also, another interesting feature of this bill is by introducing the jurisdiction blacklisting provision, which respects to permissibility of cross-border data processing activities. As blacklisting jurisdiction, they provides ease of doing business to Indian entities. Also, this bill regulates transfer of personal data outside India, as the central government will notify countries where a data fiduciary may transfer the personal data. However, such transfers will be limited by certain terms and conditions. Now, while this bill seems to offer a lot of powers to individual, there are some limitations as well. Let us discuss this limitation in the next slide. Now, the first issue that pertains to Digital Personal Data Protection Bill, it lies with dilution of power of Data Protection Board. Now, one contentious issue is that the center's authority to appoint members to this Data Protection Board, it raises concerns about potential control over the institution, especially in the cases where the government has a vested interest. Additionally, this bill also includes provisions which allow central government to bypass the requirement for express consent from citizens in certain situations. Thereby, the much debated deemed consent clause has now been given color in a form of legitimate use, which encompasses instances where individuals they willingly provide personal data without indicating objections to its use. Further, there are also concerns which pertains to dilution of Right to Information Act. As this bill, it has a provision to amend the act that would further prohibit the sharing of details which are linked to personal information of government officials. Further, this bill also provides certain exemptions. These includes rights of data principals and obligation of data fiduciary will not be applicable in specified cases, which include cases that are related to prevention and investigation of offences as well as enforcement of a legal right. Further, the central government, by notification, it may exempt certain activities from the application of this bill. These include data processing by government entities in interest of security of state and public order, research archiving, or for statistical purposes. Further, another area of concern with this bill is that it provides exemption to any instrumentality of the state from adverse consequences which might be based on reasons such as national security, relation with foreign government, and maintenance of public order. At the last, this bill also overrides Section 43A of the Information Technology Act of the year 2000. As this provision, it required the companies who mishandle user data to provide for compensation. Hence, from this bill, it is quite clear that throughout these 5 years, the original legislation it underwent several iterations. It began as a draft which aligned with Europeans' privacy protection and it emphasized citizens' empowerment in controlling their online data. However, midway in the process, certain provisions they were incorporated into this bill which accommodated the interest of companies and fostering ease of doing business. As a result, this final bill it provides some mixed approach. As on one hand, it includes robust provisions which regulates how private entities they handle their users' personal data. While on the other hand, many of these safeguards they are not applied to center itself, which enjoys extensive exemptions and considerable control over the enforcement process. Hence, this was all for today's discussion on Digital Personal Data Protection Bill of the year 2023. Now moving on to the last article of the day that appeared on August 2nd in the Indian Express. Now this article reports that the UK government it reaffirmed its support for projects which capture and store carbon dioxide emissions and it is a part of its effort to reach the net zero goals. And hence carbon capture and storage topic is important from GS paper 3 perspective as it deals with science and technological developments and their application and effects in everyday life. Further, reducing the carbon emission is also important to control the harmful effects of global warming. And it is also important from Main's perspective, as you can see from this PYQ of the year 2014 on pursuit of carbon credit and clean developmental mechanism. Also, in the prelims of the year 2017, a question appeared on carbon sequestration. Hence, in the scope of today's discussion, we will first take a look at what is a carbon capture and storage solutions. Also, we will discuss the process that is involved in carbon capture and storage and then we'll deal with advantages and challenges of carbon capture and storage mechanisms. Hence, let us start our today's discussion with what is a carbon capture and storage mechanism. Now the carbon capture and storage, also known as CCS, it is also known as carbon sequestration and it encompasses various technologies that are aimed at combating the global warming. Now these technologies, they capture CO2 emissions which may be done from power stations, industrial facilities and they even directly capture carbon dioxide from the atmosphere. And these captured carbon dioxide is then securely stored in an underground facility. This process of carbon sequestration, it involves long-term storage of carbon dioxide or other carbon forms. It serves to alleviate or delay the impact of global warming. Now this approach, it has been suggested as a means to reduce the buildup of greenhouse gases which may be emitted in atmosphere and oceans. Now this carbon sequestration, they can be accomplished by injecting carbons into a designated carbon sinks. And these carbon sinks, they can either be natural such as ocean, forest or soils or they can also be artificial such as depleted oil reserve or unminable mines. Now carbon capture technology, they have been in use for many years. However, more recently, the focus has shifted towards capturing carbon dioxide for environmental reasons. Now there are three processes that are involved in carbon capture and storage. The first is that of capturing the CO2 which is extracted. The CO2, it is trapped and separated from other gases. Now this captured CO2 is then transported to a storage facility which may be located at any location. And finally, this CO2 is stored far away from the atmosphere, either in an underground cavern or deep in the ocean. Now there are several advantages and disadvantages of carbon sequestration. First, let us deal with advantages. As carbon sequestration may also involve use of natural resources such as planting trees and managing their growth, it can prove beneficial for reducing harmful particulate matter in the air, and this will eventually promote better air quality. Further, carbon sequestration, it prevents carbon from entering into the atmosphere, thereby effectively reducing the carbon footprint in the economy. Further, by reducing carbon in the atmosphere, the greenhouse gas effect will be lessened, and this will lead to mitigation of impacts of climate change. However, there are several challenges which are associated with carbon capture and storage. First is that storing of carbon dioxide into deep underground facilities, it requires the carbon dioxide to be changed into liquid state, and it may prove challenging in some geological setting. Further, due to faults in reservoir design, rock fissures, or tectonic processes, it can potentially lead to release of stored gas into the ocean in an unintended way, thereby leading to further carbon dioxide emissions. Also, there are significant costs that are associated with carbon capture and storage. As the financial cost, they are very high and they can vary depending upon the type of technology that is utilized. And hence, the costs they tend to rise with this increased scale of carbon capture and storage processes. However, the IPCC report, it highlighted that carbon sequestration is a feasible approach to attain zero emissions by the year of 2015. Thereby, it will safeguard the planet from increase of global warming. Hence, to make the carbon sequestration viable, there should be a deep focus on developing accessible and affordable technologies which will be provided to all based on principles of equity and climate justice. Hence, this was all for today's discussion on carbon capture and storage.